meeting number 24 of the House of Commons Standing Committee on Finance, pursuant to Standing Order 108-2 and the committee's motion adopted on Thursday, November 19th, 2020. The committee is meeting to study government spending, We Charity, and the Canada Student Service Grant. Today's meeting is taking place in a hybrid format pursuant to the House Order of January 25th, 2021, and therefore members are attending in person in the room and remotely using the Zoom application. Proceedings will be made available via the House Commons website, and so that you're aware, the webcast will always show the person speaking rather than the entirety of the committee. Before I welcome our witnesses, we have two quick pieces of business. One is a request for a project budget for Bill C-208, an act to amend the Income Tax Act to transfer a small business, a family farm, or fishing or corporation. That request is in the amount of $1,275. I believe people received a copy of that. Moved by Mr. Falk. All those in favor? Opposed? Carried. The second is a request for a project budget relating to the COVID-19 expenses. I believe it should be on here somewhere. Yep. That the COVID-19 spending and programs, and the amount requested for that study at the moment is $3,025. Do you have any movers on that one? Somebody going to move that? Okay, moved by Ms. Kotrakis. All those in favor? Opposed? Carried. So there, Mr. Clerk, is authorization for those two budgets. Then with that, I see Mr. Fraser is here. Do you want to do the sound check? And then we'll go to Mr. Dufresne.
Hello, Mr. Fraser.
Excellent. Thank you, Mr. Chair. And look, I'll extend my apologies. I had a forced restart and updates applied at the most inconvenient time, just as our meeting was getting started. Hopefully, Mr. Clerk, the sound is okay. Lower the boom.
No, actually, just raise it. Just a
raise
between your nose and your mouth.
I think I've got it in the right position now. Is this more effective for you, Mr. Clerk? I'll look. Excellent. Thank you.
We're all okay. Oh, and there's Mr. Polyev. We might as well get him all wired up and tested too. We haven't seen him for a while. Pierre, do you want to do a test?
Testing, 1, 2, 3.
We're asking just a bit more audio, please.
Good day. Nice to be back with you.
Okay, I'm getting a thumbs up, and we only have Mr. McLeod that we haven't tested.
I was worried on Mr. Polyev that since he left us, he was running short on words or something, which was unusual, I thought. Michael.
I want to save them up for later. Don't want to run out.
Are you there, Michael? I see his...
Hi, can you see me or hear me?
We can hear you.
Hello, hello.
We seem to be having issues with Mr. McLeod, so we'll ask the IT ambassadors to contact his office, and maybe we could just get going.
Okay, all right. I could hear him, but we couldn't see him. But okay. With that, as I said earlier, we are meeting on the we issue and the study related to that, and our invitation to the Law Clerk and Parliamentary Council to come before committee. So I'd like to welcome our witnesses now, Philip Dufresne, Law Clerk and Parliamentary Counsel, and Marie-Sophia Gauthier, Legal Counsel Office of the Law Clerk and Parliamentary Council. Welcome to you both, and I believe, Mr. Dufresne, you have an opening remarks. Floor is yours. Welcome.
I do, Mr. Chair. Thank you, and I hope everyone can hear me well. Alors, Monsieur le Président,
So, Mr. Chair, members of the committee, I thank you for your invitation to appear today following the motions that were adopted by this committee on July 7th and November 19th, respectively, ordering the production of documents related to the We Charity and Me to We. As the Law Clerk and Parliamentary Counsel for the House of Commons, I'm pleased to be here today to address any questions that the committee may have with respect to these motions. I hope that my answers will assist the committee in its works.
Take a few moments to highlight the committee's powers to send for documents. The House has certain powers that are essential to its work and part of its collective privileges. As the grand inquest of the nation, the House has the right to institute and conduct inquiries, and this right is part of the House's privileges, immunities, and powers, which are rooted in the preamble in Section 18 of the Constitution Act 1867 and Section 4 of the Parliament of Canada Act. Indeed, these rights and this fundamental role have been recognized by courts and include the constitutional power to send for persons, documents, and records. As Speaker Milliken stated in his landmark ruling of April 27, 2010, regarding the production of documents to the Special Committee on the Canadian Mission in Afghanistan, the right to order the production of documents is fundamental to Parliament's proper functioning, and the rights are as old as Parliament itself. Speaker Milliken went on to say, the standing orders do not delimit the power to order the production of papers and records. The result is a broad absolute power that on the surface appears to be without restriction. There is no limit on the type of papers likely to be requested. The only prerequisite is that the papers exist in hard copy or electronic format and that they are located in Canada. No statute or practice diminishes the fullness of the power rooted in the House privileges unless there's an explicit legal provision to that effect or unless the House adopts a specific resolution limiting the power. The House has never set a limit on this power to order the production of papers and records, end quote. Le Parlement a le droit de...
Parliament has the right to send for any and all documents that it believes are necessary for its information. The only limitations are that the document or record must exist and it must be located in Canada. The House and its committee's powers to order the production of records constitute a constitutional parliamentary privilege that supersedes statutory law, which is why committees are not constrained by the statutory obligations contained in legislation like the Access to Information Act or the Privacy Act. When committees ask for documents, they are entitled to receive them, subject only to the exceptions or limitations to disclosure explicitly provided for by the committee itself. With that said, in exercising this power, committees should strive to balance their roles as the grand inquest of the nation against the legitimate public policy considerations that may justify limiting the disclosure of the requested information in a public setting, be it cabinet confidence, national security, or other claims of confidentiality.
Claim, the committee has a number of options. It can decide not to insist on the production of documents. It can decide to put in measures that would safeguard the confidential nature of certain information, or it can simply maintain its original request for the information. Some of the measures that a committee could take to ensure that information is kept confidential while it is being consulted include reviewing the information in camera, having my office review and or redact documents as appropriate to ensure that a claim...
Point of order, Mr. Chair. I'm just, and I apologize, Mr. Clerk. I think there might be a technical issue. I just have gotten a note saying that staff members may have been kicked off the line and cannot hear what may be going on. Mr. Clerk, is there any kind of a technical error that you're aware of?
So we don't seem to have any technical issues at the moment. I'm looking at the list of attendees, and I have a lot of MP's office staff there. They're all present. So I'm not sure who's been kicked out. Maybe they can reach out to me, and we can perhaps reach out to their specific office. It might be an isolated case.
I think it may be the telephone line. So I'll send a note just to make sure that they can reach out to you. Thank you. Can you assess whether there's an issue with the telephone line from where you are?
Yeah, I'll look into it.
Thank you.
Thank you, Sean, Madam Clerk. Mr. Dufresne.
Thank you. And so some of these options include having my office review and or redact documents as appropriate to ensure that a claim for confidentiality is justified, asking the party providing the documents to redact certain types of information, requesting a limited and numbered paper copies, or arranging for the disposal or destruction of copies after the committee meeting. It is for the House and its committees to make this determination and to set the parameters on the disclosure of documents being produced. If a committee's order is not complied with, the committee may report the refusal to the House. Ultimately, the House has the final say and may order the production of any documents or impose sanctions. In this instance, the committee adopted a motion on July 7th, 2020, ordering that the government produce documents related to We Charity and Me to We. The motion expressly provided that matters of cabinet confidence and national security be excluded from the request. It also required that any redactions necessary, including to protect the privacy of Canadian citizens and permanent residents whose names and personal information may be included in the documents, as well as public servants who have been providing assistance on this matter, be made by my office. Le gouvernement a fourni les documents de
The government provided the requested documents to the committee, and they were in turn given to my office so that we could make the necessary redactions. After reviewing and redacting the documents in accordance with this committee's order, I reported to the committee by way of letter on August 18th. In my report, I noted that the documents produced by the government had already been redacted and that certain grounds were not contemplated by the committee's order. My office had not been given the opportunity to see the unredacted documents and could therefore not confirm whether those redactions were consistent with the committee's order. I concluded that in the circumstances, it was for this committee to determine whether it was satisfied with the documents as redacted by the departments. As stated previously, when faced with a claim of confidentiality, it is up to the committee to determine whether to accept the ground that is being put forward.
The committee adopted another motion, ordering that the government provide to me all documents as originally requested in the July 7th motion, including all documents the government provided in August, without any redactions, omissions, or exclusions, except as was justified originally in subsection 69 through 69(3)(b)(2) of the Access to Information Act, namely cabinet confidences. The motion also provided that I would use the information to determine the government's compliance or non-compliance with the July 7th motion. On November 24th, 2020, my office received the documents from the government that were provided in response to the July 7th motion, but this time without redactions, omissions, or exclusions, except for matters of cabinet confidence or lack of relevance. On December 14th, the government provided my office with pages that were missing from the French package. The documents provided in response to this committee's motion of July 7th and November 19th contained redactions for matters of cabinet confidences. I do not take issue with these redactions as cabinet confidences were expressly excluded from both motions. Based on our review of the documents provided to my office in November and December 2020, I can confirm that some of the government's redactions are based on grounds that were not contemplated by the committee's order of July 7th, but are rather rooted in the Access to Information Act. Specifically, those grounds are personal information. While the July 7th motion contemplated that personal information be redacted, the committee entrusted these redactions to my office and not the government. Third-party information, information on the vulnerability of the government's computer or communication systems or methods employed to protect their systems, solicitor-client privilege, and to protect accounts of consultations or deliberations in which directors, officers, or employees of a government institution, a minister of the Crown, or the staff of a minister participated.
I can confirm that these redactions relate to information that would be exempt from disclosure under the Access to Information Act. However, as mentioned in my report to this committee of last August, the House and its committees are not subject to these statutory restrictions. Should this committee agree to allow the redaction of documents on the grounds I've just mentioned, I can confirm that the manner in which the grounds were interpreted by the government would be appropriate. Ultimately, it is up to the committee to determine whether it is satisfied with the documents provided in response to its order. With that, I would be pleased to answer your questions. Thank you.
Okay, thank you, Mr. Dufresne, and we will go to the question 6-minute round first. The lineup is Mr. Poilievre, Mr. Fragiskatis, Mr. St. Marie, and Mr. Julian. Starting with Mr. Poilievre. The floor is yours, Pierre.
Thank you, Chair, and thank you, Clerk, for your broad context. Now we'll get down to some binary yes or no questions. Did the government provide you, excuse me, did the government provide this committee with all of the content the committee requested in its original July 7th motion?
The information that was provided excluded cabinet confidence information and included information that was found to be not relevant, so beyond the scope of the initial motion.
Sorry, I think you might have misunderstood the question. I'm not asking about what you received. I'm asking about what the committee has thus far received unredacted. Has the committee received all of the information that the committee requested in its July 7th motion?
It has received what it has asked for, with the exception of the redactions that I've highlighted on those categories under the access to information legislation that the committee did not include as valid grounds in its motion.
And the Access to Information Act exemptions and exclusions, do they apply to requests by Parliament for papers and records?
They do not apply to those requests unless the committee decides to include those grounds in its motion.
Did the July 7th motion allow those grounds for exclusion or redaction?
It included the ground of cabinet confidence, but not the ones that I've listed: third-party information, information on vulnerability of government's computers, solicitor-client privilege, and consultations. Those were not included. Personal information was included, but it was meant for my office to redact and not the government.
Okay. So then, again, did the government provide the committee with all the information the committee requested in its July 7th motion?
No, because it invoked those grounds that the committee did not allow.
And those grounds are not legally legitimate. Okay, so the next question is, the government has excluded documents on the grounds of cabinet confidence. Can you confirm, yes or no, whether the government accurately applied the grounds of cabinet confidence?
I cannot confirm that, Mr. Poilievre. I have not seen behind those redactions. The motion in November provided that those redactions could be kept by the government when it sent me the new package.
Right. So we don't know one way or the other whether or not those exclusions are properly applied. How much time do I have, Mr. Chair?
You've still got about 4 minutes.
3
minutes. Sorry, Pierre, 3 minutes.
On a related matter, Mr. Dufresne, you are the chief legal counsel to Parliament. You know its powers better than anyone. Your office sent me a briefing note today telling me that the power of Parliament to send for persons is part of the privileges, rights, and immunities of the House of Commons, which is inherited when it was created and are found in Section 18 of the Constitution Act 1867 and Section 4 of the Parliament of Canada Act. Now that in the related committee, Ethics Committee, the Kielburger brothers has refused to appear and refused an invitation from Parliament, can Parliament issue a summons and force them to appear before that committee? And if they still refuse,
order relevance. Point of order, Mr. Chair, relevance.
I see the government's very sensitive about this, and they'd like to cover up this conversation. We'll let Canadians decide what's relevant.
Oops, sorry there. What's your point of order?
We are here to have the law clerk testify before us about the compliance or non-compliance with the July 7 motion. I'm not quite sure what the relevance is as to bringing in the we and whether the heads of the we organization are going to be coming before the ethics committee.
Point of order.
I am going to allow the discussion because the discussion is with the law clerk here. I think pretty near any question that relates to the legality of what committees can do would be relevant in this discussion with the law clerk. Your point of order, whoever it was it Mr. Falk or who?
No, it was.
Sorry, Mr. Julian.
Mr. Julian, thank you, Mr. Chair, and you're absolutely right. The subject today is compliance with committees, and so your ruling is absolutely appropriate.
Okay, back to you, Mr. Poilievre. I've lost track of time. I think you got 2 minutes and a half left.
If the Ethics Committee makes a summons for the Kielburgers to appear and they refuse, what law enforcement powers can Parliament order in order to compel testimony?
So in the situation where a summons is issued by a committee and the witness continues to refuse to appear, the committee does not have enforcement powers itself, but it would need to, if it chose, report the matter to the House. And the House would then consider it under its authority.
And the House, and if the House were to decide that the Kielburgers had to testify, what enforcement powers and enforcement bodies could it use to do so?
The House could consider the matter in terms of issues of contempt of Parliament. It could consider the matter in terms of summoning individual to the bar of the House and to explain the refusal to appear.
And if they refuse to come to the bar of the House, what then? What powers then would the House have to compel them to appear if the House so wished?
Well, this is discussed in procedures and practice in terms of censure, reprimanding, summoning individuals to the House. The House would consider whether could consider whether it's a contempt of its privileges and make a finding to that effect. Historically, there has been the authority to summons and issue a warrant to bring an individual into custody and bring the individual to the bar of the House. That has not been done in Canada since 1913, and the circumstances are discussed in procedure and practice. So it's not something that we see.
So the last question, Pierre.
So to conclude, we've got confirmation the government did not provide the committee with the documents that it requested in its July 7th motion, that the law clerk has no way of knowing if the government has been honest and forthright in its use of the cabinet confidentiality exemption, and the hundreds of pages of information that are covered are excluded on that basis may or may not be cabinet confidentiality, and that the House has legal enforcement abilities to compel testimony from the Kielburgers. So that is a summary of what I think we've just heard. I want to thank the law clerk for appearing here today and for his work.
And we will give the law clerk the opportunity to respond to that statement. Mr. Clerk, Mr. Dufresne.
Well, I think I've given the answers. I think to the questions, in that there were grounds that were invoked that were not included in the motion with respect to the cabinet confidence. I have not seen those. The motion in November did not provide that I would see behind those cabinet confidences. And in terms of the House's powers, those are set out in procedures and practice and include those elements that I've listed.
Okay, thank you both. Mr. Fragiskatis, Peter, 6 minutes, followed by Ms. Gill, sorry.
Thank you, Mr. Chair. Thank you, Mr. Dufresne, for being here. I want to ask you a question relating to the law and principles that underpin our legal system. Are you of the view that solicitor-client privilege is fundamental to a legal system in a democratic society?
I am.
Okay. I point this out because in your remarks, you stated, and I wrote it down here, so I'll just read it for the record. Some of the government's redactions are based on grounds not contemplated by the July 7th motion, which is the part that Mr. Poilievre heard. I acknowledge that that's the part he heard. What he, it seems, did not hear is the rest, where you said, but that are rooted in the Access to Information Act. You mentioned solicitor-client privilege. You've affirmed the importance of the solicitor-client privilege to our legal system in Canada. There's other examples that you give, including personal information, which, you know, and I put this to my colleagues on the committee. I think it's very important that the personal information of public servants and other third parties, is protected. Unless Mr. Poilievre wants the cell phone number of certain public servants or email addresses so he can call or email them, I'm sure he's up to it. I'm sure he would do that. But I don't think that's really important. I think that that information is protected. I know it's protected under the Access to Information Act, which is a critical thing. Mr. Chair, I'll continue here. Would you, Mr. Dufresne, have made the same redactions?
I would have.
If it was up to you.
Well, if the committee allowed those grounds, and that's how I concluded my remarks.
Let me put it another way. Were the redactions consistent with the Privacy Act and other relevant acts?
They were, in my view, consistent with those acts and those definitions. And so, again, if the committee agrees that those grounds ought to be accepted, my testimony here today is that they were applied by the government in a manner consistent with those definitions.
And therefore consistent with the law of Canada. Mr. Dufresne, did any politically sensitive information get redacted?
We looked at the redactions on the basis of, were they consistent with the definitions, both with respect to the committee's motion language, and then in November with the grounds as defined in the Access to Information legislation. So that's how we looked at them in terms of, the government is claiming this reason for an exemption, and would it meet that definition? Again, in my view, it's necessary for the committee to accept that ground, but assuming the committee did, would it be private information? Would it be solicitor-client privilege? And in my view, that those were applied in a manner consistent with those definitions.
But where members of the opposition, whether it's Mr. Poilievre or others, point to something that was redacted, or where they raise rather suspicions that things were redacted on political grounds, politically sensitive information was excluded from the eyes of the committee, if I can put it that way. Your view is that that did not happen?
My view is that those redactions appear to have all been made on the basis of the grounds in the Access to Information Act that I've listed in my testimony.
Therefore guided by the law and not politics. Was the government ever obligated to turn over documents that were not relevant, Mr. Dufresne?
In my view, they were not.
Okay, thank you very much. I want to read, Mr. Chair, if I could. Let me just bring it up here. I have in front of me an October 19th press release issued by the Conservative Party that read as follows. There is clearly information related to this, what they term a scandal, that the government blacked out and don't want Canadians to see. Again, and forgive me if it's a repetitive point, but I think Canadians deserve the assurance. Is there any evidence that important documents relating to this contract were redacted?
What I've seen is that the information that was redacted on the basis of the grounds in the Access to Information Act that I've set up.
Thank you very much. So, Mr. Chair, what we've heard here is clear in my view, and you'll recall that in the many meetings that we had over the course of a number of months on this issue, I did not, and my Liberal colleagues did not stand in the way of us discussing the We Charity issue. We've had it confirmed now that redactions made on political grounds did not take place. Where those redactions did take place, that was consistent entirely with Canadian law. Again, things like solicitor-client privilege, things like the protection of personal information. I would ask my colleagues on the committee, if they had family members who were public servants, for example, or friends, would they want the personal cell phone number or email addresses of those individuals shared? We know the answer, and we have law in place to protect that personal information. So Mr. Poilievre will waive as he did in that infamous press conference, and I underline the word infamous in particular, Mr. Chair, he will wave papers around that look to be redacted to create another story, but there's no story here. I don't see anything nefarious that took place. I'm satisfied that the government acted in an appropriate way. Thank you very much.
Okay, I don't believe there's unless Mr. Dufresne wants to add anything else. There's more to state. Okay, Ms. Gill, 6 minutes, followed by Mr. Julian. Ms. Gill.
Merci, Monsieur. Thank you, Mr. Chairman. Thank you, Mr. Dufresne, for your testimony. I have several questions for you to try and shed some light on some points that I can't see clearly in here. According to your experience, is it current practice for officials to take charge of the redaction of documents before these be sent into the committee? It's a practice, I would say, yes. According to my experience, this is practice that we have seen regularly. So it's the officials, and perhaps I should be clearer, despite the committee's order, which is requesting that it be the law clerk and parliamentary council that take charge of those redactions. So is that also a regular practice in that light? Well, it's something that we see, certainly. It's something that we see, and that that is what I said to you in my letter this summer. It was to emphasize that. It wasn't to say necessarily that there were any motives that weren't well-founded in public policy, as I said in my remarks to the committee. And the committee will have to balance this and ask themselves why. But the committee has constitutional powers, and so it's up to the committee to decide. Indeed. So it happens. But it's up to the committee to make the decision here, so it's up to us. Is there an adjective we could use to qualify this practice? Because if it's really the right of the committee, and this is found in the Constitution Act of 1867, we should be able to have access to these documents. And the order that we have issued should be respected. We've talked about the content, but we also have to talk about the form. We talked about the substance rather than we should talk about the form. So is there some qualifier for this? Because in a way, our rights have not been respected by these officials, it seems to me. They've gone beyond what they should because they've changed the committee's order. Well, look, I don't want to comment on what the government does. I'd rather talk about the House and its committees and their powers. For me, what's important, and this was recognized by Speaker Milliken in the decision that I quoted, the House and its committees have constitutional rights and powers that have been recognized by the Supreme Court. They are the inquest of the nation, and so these laws should not limit the committee. And this is exactly what Speaker Milliken said himself in his decision. So there are some imperatives that are in the interest of the nation, and we can't minimize that. Well, yes, indeed. But the committee has to decide, as you said. So I imagine that if we had access to all of the information, because you mentioned, indeed, that even the officials went beyond what was requested as limitations by the committee itself as far as the redactions are concerned. So if I think of those elements, I think there might be some relative information for the committee within the framework of its proceedings and its studies, and therefore it would be up to the committee to judge what is relevant or not. And in having confidence in the committee, to decide what they want to see redacted by you, Mr. Dufresne. Well, what I mentioned was that it's up to the committee to decide what grounds they want to allow. If the committee allows some grounds, as they did, for example, with cabinet confidences, that information obviously would not be provided, and there's no issue then. The committee could adopt another approach. They could say, perhaps we want to look at this in camera. There are all kinds of options. Okay, well, if I go back to restate my question more simply, it's that, in fact, if we are asking for information and there's no limit to the request, we can decide to impose certain limits. You said that very clearly, but there's a potential concerning other studies. We're talking about We Charity here, but the relevance of information might be different. So the person might decide to go further in terms of the substance of the information. But in any case, those officials are deciding for the committee what's relevant to the study or not. Is that not correct? Well, I think that the relevance is a basic quality for this information to be included at all. If it's not, then why should it be included? But the point is should this information be protected in terms of confidentiality? Is there sufficient justification to determine that? And that's a question that we're constantly asking ourselves. Okay, I just want to clarify, if it's up to the committee to decide the information, what information it wants to have, the committee also would be the entity to decide on the relevancy of it, and not the officials who receive the request. Well, the committee decides on the relevancy when they set out their motion and when they're requesting the documents. That determines the relevancy. But the second issue is, what grounds are you going to accept in terms of confidentiality? Do I have 5 seconds left? You have some time. Okay, well, I might talk quickly about the French. Why did we receive some documents in French only on the 14th of December? I'm just looking for a clarification on that. It was just some documents that were inadvertently not sent along with the rest, and it was an administrative error. It was corrected afterwards. Thank you very much.
For that, Mr. Julian, followed by Mr. Poilievre. Mr. Julian.
Thanks very much, Mr. Chair, and thank you, Mr. Dufresne, Madame Gauthier, for your presence here today and your work on behalf of elected officials. And we hope that you and your families continue to stay safe during this pandemic. Mr. Dufresne, I wanted to come back to your initial points around the editing or the censoring of the documents going beyond the committee order. You referenced the Access to Information Act. Of course, that Access to Information Act is highly criticized. In many respects, it's a hiding Access to Information Act because of the grounds for exclusion. So I'm very interested in knowing just to what degree the government went far beyond the committee's order of July 7th, which now is obvious, and that fortunately your examination has indicated. So I would like to know how many pages were redacted or blacked out under the grounds that are wide on access to information of personal information or third-party information. How many of the pages were blacked out because of that?
I will see if I can provide that information, Mr. Julian, perhaps in terms of percentages of redactions. What we had, the ground of privacy amounted to 4%. The ground of third-party information amounted to 1%.
And this is on a basis of 3,000 pages?
5,000.
5,000. So we're actually talking about 50 pages on third party and about 200 pages on personal information.
Well, this is where the redactions, and Ms. Gauthier can correct me, but this is where the redactions appear on a given document.
Okay, thank you. And for information on the vulnerability of the government's computer communication systems and solicitor client privilege, what percentage of the 5,000 pages was there?
Solicitor client privilege was minimal, so 0%. There was one instance, and vulnerabilities would be 2%.
2%, so about 100 pages. And then for protecting accounts of consultations or deliberations in which directors, officers, or employees of a government institution, a minister of the Crown, or the staff of a minister participated.
Very minimal, 0%.
But it was cited.
Right.
So
it was cited on about three documents.
Yeah. So we're talking about a few hundred pages, just the same. And given I know you can't comment. You have to comment on the law as it is. But our Access to Information Act is highly criticized because of the vast exemptions you can drive a truck through, and it's a matter of frustration for many parliamentarians. So thank you for that. Now, going to the issue of respecting a committee summons and the Kielburger brothers, there have been recent allegations that have come out despite the abrupt prorogation in August and the months of chaos we had in this committee due to Liberal filibusters. Very serious allegations of abuse of charitable contributions and abuse of charitable funds. Of course, it's important that committees get to the bottom of that. You've indicated that a committee that issues a summons that is ignored can report the matter to the House. The House can then deliberate and have a finding of contempt of Parliament. And you cited the case of 1913. And I think it would be, for those who are tuning in, particularly from the Parliamentary Press Gallery, perhaps germane, if you could reference that last case where there's been a finding of contempt of Parliament and what the results were.
So the description of the 1913 case is set out in Procedure and Practice, page 132, and it indicates that in 1913, R.C. Miller, a witness before the Public Accounts Committee, refused to answer questions. This was reported to the House, whereupon it adopted a motion summoning Mr. Miller to appear before the bar and answer questions. Mr. Miller made 2 appearances before the bar and on both occasions was permitted to have counsel. He was directed to withdraw after he refused to provide the information requested by the committee. The House then adopted a motion stating that Mr. Miller was in contempt of the House and that he should be imprisoned. Mr. Miller was again brought before the bar and the resolution was read to him. And it goes on to say no private citizen has been called to the bar since 1913. And so certainly not something that we see.
Last question, Peter.
Thank you. So I certainly hope, as you do, that as we all do, I believe, that the Kielburger brothers will respond to a committee summons. But ultimately, this is quite unprecedented for witnesses to say that they refuse to respond to a committee summons. And if that is the case, as you've cited in 1913, there can be somewhat serious consequences.
Well, it is something that can be reported to the House, and the House has its powers to address those matters.
Okay, we'll pick up that other 20 seconds in your next round, Peter. Turning then to Mr. Poilievre, a 5-minute round, who will be followed by Ms. Zerowitz.
Thank you. So, if the House of Commons passes a motion insisting that the Kielburger brothers honor the committee's request to testify, and the Kielburger brothers refuse, there is precedent for the House to order law enforcement to imprison and compel testimony before the House or one of its committees. Do I understand that correct?
There is the precedent that I've highlighted. It is an old precedent. It is more than 100 years old. So that is factored into the strength of that.
Well, if it's old, it means it survived the test of time. And certainly we have the unmitigated right to call for persons to answer questions. And if that right is not upheld, then we as parliamentarians have a duty to use law enforcement in order to uphold it. And that is what we will do if the Kielburgers refuse to answer the questions we are asking. You have said that the government excluded from the documents it gave you information that it considered lacking in relevance. Where in our November motion did we allow the government to exclude documents it considered irrelevant?
Well, I think that the November motion was predicated on the documents that had initially been requested in July.
Yep, that's right.
And so I suppose the argument would be that if it's not requested in July, it's not requested in November.
But it was requested. And what the motion said is that all documents that have been requested in July should be provided to you unredacted, with the only exception being cabinet confidences, not cabinet confidences and documents that the government considered to lack relevance. So you have still not received all the documents that the November motion indicated you should receive.
Well, it's up to the committee to interpret to interpret its motions. What I can point to is that if something is not part of the request from the committee initially in July, so if it's not relevant to the July motion, it's arguable that it was not requested.
Mr. Poilievre, Mr. Dufresne has the floor. Allow him to complete his answer. Mr. Dufresne.
I think it was complete. I think I've made it.
Allow me to clarify here. Are there a number of documents that they blacked out and handed to you covered up, and on the grounds that they were irrelevant? Is that what happened?
There were some pages where an indication was out of scope. Pages are not relevant.
Okay, how many pages was that?
I'm not sure I have that information. Let me see if I have that in my statistics. Perhaps this is something that Ms. Gauthier can provide, or we can provide it to the committee.
Come back to me on that. But the point is that we specifically decided as a committee in November to include documents that had originally been blacked out on the grounds of relevance. In fact, the government had tried to broker a compromise to exclude those documents it considered to be relevant. We refused that, and we insisted that documents and content that they had previously said was irrelevant be included for your eyes to see. That is why the motion is very clear that the only exceptions are supposed to be those found in section 69.1 through 69.3b.1.2 of the Access to Information Act. Those sections exclusively deal with cabinet confidentiality. The government was not authorized to exclude whatever it considered irrelevant. So you're now telling us that they applied an exemption that wasn't in that motion. Is that true?
Well, the ground of not relevance was not set out in the November motion. That's correct.
That's right. Because the only justifiable exclusion was if it was a cabinet confidence. Now you're telling me that the government, we're just supposed to believe them when they say that these additional redactions only dealt with things that were, in their eyes, not relevant. Well, I suspect they believe nothing is relevant. If there was the smoking gun in the WE scandal, they would say, oh my goodness, that's not relevant. You don't need to see that. We'll just put a little bit of black ink over it. That's specifically why we insisted that you and not they be responsible for determining relevance. But you're now revealing today that they've blacked out all kinds of content, potentially whole pages or more, on the grounds that they didn't consider it relevant.
A final question there, Pierre. Mr.
Is there
Dufresne?
anything inaccurate about what I've just said?
Well, I've stated that there are some pages that are redacted on relevance.
Jeez, they've really got something to hide here, folks.
Thank you both. We'll now go to Ms. Zurwitz, followed by Ms. Gill.
Thank you so much, Mr. Chair, and thank you, Mr. Dufresne, for being here with us today. Maybe I'll start off just with a question on where Mr. Poilievre has ended. So in terms of if portions of documents were not relevant and they were left in, and if in fact the government provided you with all of the pages of the irrelevant documents in its possession, do you believe that it would have helped or hindered your work?
Well, I think the issue is whether the committee wants me to look behind redactions on the basis of relevance, and so that's really the determination for this committee. One interpretation would be that if it's not relevant, it's not requested at all in the initial motion, so it was never requested. But it's up to the committee to decide how much it wants to review.
Right, and also if we had not given it, then no one would have ever noticed whether it existed or not. So, okay, so I want to go back just a little bit. So we started with the July 7th motion, which was requesting a certain number of documents. Then you had indicated to us that our civil servants decided that they were going to additionally exclude certain bits of information as per the Access to Information Act. And so you list those off very well in your comments today: the personal information, the third party, the solicitor-client privilege, etc. I just want to be clear. I just want to make sure that have you seen any evidence that there was any political interference in applying the Access to Information Act, or whether this was just done by the civil servants?
From what I saw, it appears to have been done by civil servants, and the grounds. Now, I can't really know that, but what I can say is that they have been applied in a way that, in my view, is consistent with those definitions in the Access to Information Act.
And I believe you've also indicated that this is fairly typical for our civil servants to do in terms of applying this type of Access to Information Act lens.
I have seen it from time to time. As I say, it's something that I raise with committees, and in the sense that, in my view, it's up to committees to decide whether they will accept those grounds. But it is a practice that we see the government taking.
And then, Mr. Dufresne, could you explain why would what would be the public interest behind actually excluding the things like solicitor-client privilege and things like consultations or deliberations and advice to ministers? What would be the public interest in our civil servants doing so?
Well, the public interest grounds behind Parliament having included those in the Access to Information Act as exemptions, I think for solicitor-client privilege, it is the need to ensure that confidentiality so that clients can obtain solicitor-client, can obtain advice. Deliberations of government have to do with receiving frank advice when making decisions, considering options. Third-party information is to protect competitive positions and trade secrets and other matters for third parties. Personal information is to protect individuals' personal information and dignity and these types of information. So there are some public policy considerations behind those grounds, and they have to do with that information being made public in large measure. And so, as I've stated in my remarks, committees ought to give weight to those public policy factors, in my view, but it is up to committees to decide how to balance. And there may be different circumstances, and there may be different options. In certain instances, the Speaker Milliken's decision in the Afghan detainee had to do with national security, certainly a major public policy consideration. But the House and Speaker found that the committee nonetheless had the power to request that information, but they put in place a mechanism so that it could be done confidentially.
Last question, Ms. Hurwitz.
Sure. I'll ask a question. I just wanted to sort of just indicate that, the clerk of our Privy Council has come before us and has let us know that his intent had been to be as expansive as possible in relation to the information that he had released. And I just want to make sure that that statement is on record, even though they had gone beyond what was asked for in the July 7th. That was the intent, and I think he followed that intent. So my last question is it fair to say that the committee does have a number of options to deal with the outstanding concerns if there's some information that we feel we might need to see, whether it's in camera or not, some of the options? So is it fair to say that we do have a number of options to sort of look at that right now?
I would agree with that, yes.
Okay, thank you so much.
Okay, thank you. Then 2.5 minutes, Ms. Gill, and then over to Mr. Julian for about 3.
Merci, Monsieur le Président.
Thank you, Mr. Speaker. I hope that the government, I hope it's not from that perspective that what my colleague from Davenport has said, because my colleague from Davenport said that if it wasn't the document wasn't provided, then it wasn't relevant, and we come back to this point again. And I say once again that it's up to the committee to decide what is relevant or not. So, Mr. Dufresne, perhaps I could get further into what I was asking you about earlier in terms of experience that you have with this kind of redaction on the part of officials. Because Mr. Shugart had said to the committee that he had sent a message to the system if there were any questions or difficulties of interpretation.
Made the point of order. Who had it?
Sorry, Mr. Chair,
Peter.
It's me. I'm not sure if it's only on my end, but I'm having an issue with interpretation.
Okay. Just Mr. Clerk, shut off my clock here.
I can
Mr.
only
Clerk, can you
faintly
check that
hear
out?
the translation. I mostly hear Madame Gill. My French is improving, but it is not. I'm not bilingual at this point, so just wanted to flag that.
Madame Gill, is your are you on French on your system there?
Oui, bien sûr.
Yes, of course.
Lose your time there, Madame Gill. Go ahead.
Est-ce que vous voulez que je
Do you want me to start over again, Mr. Chairman? I don't know at what point Mr. Fradziskatos lost me.
Donc,
Okay. So I'm hoping that the government had another intent when they decided that the officials would be able to redact the document, other than what my colleague from Davenport was just mentioning, saying that if the documents weren't provided to us, then no one would notice, I believe is what she said. So I'm concerned about that, because I think that the relevancy, of course, is in the domain of the committee. It's up to us to determine, and not people outside. Or indeed, it could be decided by the law clerk. It could be his responsibility. And so on that note, Mr. Dufresne, I'd like to go a bit further than the last question I asked you regarding the experience that you have in the area of redaction, because, and I want to repeat what Mr. Shugart said, you know him, that I sent the message into the system that there were any questions of difficulty of interpretation or instructions, that the officials could ask their questions of the Privy Council office, and ultimately I'm responsible. And so I'm wondering if you find it strange that it be the top civil servant in the that would be asking the various departments to redact these documents, and is that something that's regularly and currently done? I don't find that irregular or problematic at all, coming from the Privy Council office. I think that that is a reputable request to make of the public service, and I heard Mr. Shugart's testimony before you. What I take from that is that the clerk's position is that they are bound by the Access to Information Act, and that they have to respect that. He also spoke of cabinet confidences and the position that they take, to the effect that they must make those redactions on those grounds. So that's the way I interpret it. And, well, I'm sorry, I don't want to interrupt you, but I have so little time. Do you feel that this becomes a custom? because it shouldn't be the officials who are doing that redaction. You're the one who was supposed to do it. And I come from a union background, and so perhaps we are getting into subcontractors and people who aren't respecting collective agreements or something. But do you think it's normal for them to do the job that should be your responsibility? Well, look, I am the principal lawyer of the House, and my role is to defend the interests of the legislator and the legislative branch and the institution. So from my perspective, the House has the constitutional power, which is superior to any law, such as the Access to Information Act. So it doesn't mean that we should ignore the imperatives of public policy. However, it is up to the House to decide that. They are the decider. It's not the government. The government has its position, and Mr. Shugart presented that.
Thank you both. Then on to Mr. Julian, and we'll pick up the time you lost before. 3 minutes, Peter.
Thanks very much, Mr. Chair. Thank you, Mr. Dufresne. This is very illuminating. So far we found that the documents were wholly or partially redacted, at least 300 pages, using the broad loopholes of the Access to Information Act. I find that quite disturbing. But I'd like to come back to the other element of your testimony that I find quite disturbing, and that is that other redactions, omissions, exclusions took place on matters of cabinet confidence on those grounds and on the grounds of relevance. The original motion, as you indicated, also talked about national security. So my question is, I'm presuming that national security was not cited for any of the substantial redactions that took place. How many pages were wholly or partially redacted on the grounds of matters of cabinet confidence, and how many pages were excluded wholly or partially on the grounds of relevance?
There were no exclusions on the basis of national security, and on the basis of cabinet confidences, it represented 6% of the redactions. And in terms of not relevant, I'm looking for that information, and we'll see if I can have that by the end of my appearance today. And if not, then I will forward that subsequently to the committee.
If Ms. Gauthier wants in here at any time, don't be afraid to yell, Ms. Gauthier. Go ahead, Peter.
Thank you. Yes, Madame Gauthier, if you have something to add, please don't hesitate. So we're now up to at least 600 pages. What I found disturbing when the original documents were dumped as Parliament was stripped of its powers by prorogation was the sheer size and scope of the blacking out of documents. So it was stunning to me as a member of committee to see just to what extent the government was ripping apart what had been a very, very clear indication of the importance of obtaining those documents. So if we're looking at now at 600 pages plus whatever was redacted out on the basis of relevance, I would be interested, Mr. Dufresne, in having you talk about what the committee's options are going forward. We have what is still a substantial redaction of the original request. What options do we have as committee members to get to the bottom of this scandal?
So, Mr. Julian, some of the options I've set out, and I'll repeat them. So, the committee could ask to review some of that information in camera so that it can satisfy itself of what's behind. It could ask that more information be provided as to the reasoning behind it, or it could accept the grounds, and it could determine that those grounds are grounds that can be incorporated in the committee's order. So it's really those approaches where you accept it, you don't accept it, or you find some ways that you can have access to it, perhaps confidentially, perhaps with other rules.
Okay, thank you. Thank you both. I'm not sure. I think it's Mr. Poilievre. There you are. Mr. Poilievre, you're on, followed by Mr. Fraser. 5 minutes.
Mr. Clerk, do you have any way to confirm whether the government's claim that the blacked out content in the documents you received is really not relevant, as they claim?
I cannot, if I have not seen a document, or if I have not seen pages of a document, I cannot comment on it.
So in other words, it could be very relevant, but you wouldn't know because you haven't seen it.
Well, I think that's true in
Right.
Whenever a disclosure is made, you'd never know what has not been provided. So if you're provided with 1,000 pages, everything else has not been provided. So so you never know.
Exactly. And we specifically asked for that documentation to be given to you unredacted so that you could determine what was relevant and what was not, so that you, a trusted lawyer of the House of Commons and Parliament, could tell us whether the government was redacting the information because it was truly irrelevant or whether they were just covering up what they didn't want Canadians to see. But now we learned that they covered it up even from you and just said, just trust us. Everything contained under this black ink is irrelevant. You don't need to see it. Well, that is exactly the opposite of what we asked for the government to do and what the members on this committee agreed to do. And shame on all the Liberal members on this committee who specifically committed to this. Mr. Fraser specifically committed to me that the disclosure from the government would include unredacted the information that they had previously claimed was irrelevant. And that is not what happened. So they did not keep their word. And shame on them for deceiving Canadians, deceiving their fellow parliamentarians. Let me move on now to the subject of bringing in witnesses who refuse to cooperate. Your report to me says that the House of Commons possesses the right to confine individuals as a punishment for contempt. You further go on to say that the House ordered the Sergeant at Arms to take individuals into custody on 4 occasions and ordered the imprisonment of others. So the House of Commons, should it so wish, could have law enforcement authorities take the Kielburgers into custody and compel them to testify if it so wishes and if they refuse. Is that an accurate reading of the report you gave me?
Well, I think the report lists some of the precedents from procedure and practice, and the latest one is 1913, as I indicated. The other ones are even older than that. So there are precedents, they are old precedents, and so it is not something that has been done in more than 100 years.
And let me say that I hope it never has to be done again. I hope that the Kielburgers look at the powers Parliament has, these ancient authorities that we inherited from our British ancestors, and agree to appear and answer the questions honestly of parliamentarians. But I just wanted to confirm that indeed this power does exist, and if the Kielburgers refuse, then we can exercise these powers, and I have no doubt that Parliament would do exactly that. Now, Mr. Chair, how much time do I have left?
You have 1 minute and 15 seconds.
All right. And so we have today is your confirmation that the committee's unmitigated powers to request and receive information has not been fully honored, that the government is now blacking out information that it promised to release on the grounds that it interprets that information as irrelevant, that you have no way of confirming whether the information is irrelevant because they won't even let you see it, and that effectively there are hundreds of pages that continue to be covered up that we don't know what's behind them. We don't know if the cover-up is justified under the law. And so now we as parliamentarians have to decide what to do. To conclude, Mr. Dufresne, can you confirm that we as parliamentarians have the right to call any and all documents without restriction and without limitation?
You do.
Thank you.
Mr. Dufresne, there was a number of statements made there by Mr. Poilievre. Do you want to respond to them, or are you leaving it at what you said? Because Mr. Poilievre had basically said the government had not released certain things, et cetera, et cetera.
Well, I think I've stated my observations at the outset that there are grounds that are invoked that were not in the July motion.
Okay. Mr. Fraser, followed by, I'm not sure whether it'll be Mr. Poilievre or Mr. Kelly. Mr. Fraser, in any event.
Thank you very much, Mr. Chair. Before I get into my questions, Mr. Dufresne, we had the Clerk of the Privy Council testify and a batch of documents produced, including remittal letters from the deputy ministers of various departments. Have you had a chance to look at that information before your appearance today?
Yes.
One of the reasons I ask is because the clerk made very clear that the process employed in redacting the information was done free of political interference, but instead by the nonpartisan public service. I'm curious, and the purpose of your appearance here today, according to the motion that invited you, was to testify as to the compliance with the July 7th motion. You stated it's your view that the government was not required to produce materials that were subject to cabinet confidence. So can you confirm that you are of the view the government was entitled to make those redactions? And do you have any reason to believe those redactions were done in an inappropriate way?
I am of the view that the government was entitled to make those redactions as it was allowed by the committee's order, and I have not seen behind them, so I have no reason to have an opinion one way or another on them. I have no cause to be concerned about what's behind this. All I have seen is redactions made on that basis.
Similar question on the documents that were marked not relevant. Just very quickly, is it your view that the government was not required under the July 7th motion to produce material that was not requested in the July 7th motion and was therefore not relevant?
My view is that if something is beyond the scope of a motion, if it's not relevant to a motion, it's not required by the motion, but that's a determination for the committee to make.
And so long as the clerk of the Privy Council was being honest about the process that was employed, would that ensure that there were no redactions made for political reasons, but instead, assuming the clerk of the Privy Council was honest about the process that was employed, do you have any reason to believe that those redactions were inappropriate?
I do not.
Just on the issue of the other areas that you've mentioned, where there were some redactions that were made in areas such as solicitor and client privilege, I believe Mr. Fragiskatos asked if you believed that that ground was essential, and you agreed. One of the things that I'll point to in the July 7th motion is the motion suggests, and look, I will acknowledge that the motion says that it should have been your office that made the redactions as opposed to the government. But it does say any redactions necessary. One of the things that I am curious about is, given the fact that you believe solicitor and client privilege, given that you agreed with Mr. Fragiskatos, is essential, is that redacting that information would in fact be necessary?
Well, I think that at the end of the day, it's not up to me. It's up to the committee to decide what ground to accept. If it asks me, are there good public policy considerations behind that? I think they are. Does it mean that the committee cannot have access to this at all, or does it mean that it would be in camera with safeguards and so on and so forth? That's up to the committee to decide.
Sure, I understand. The reason I ask is because it says any redactions necessary, and then it says including personal information and privacy. It suggests to me that there could, in theory, be redactions made that were necessary for other reasons. If the government interpreted that to mean the legislative standard that has, as in your argument previously, has some public interest being served, Can you confirm your earlier testimony that in fact the redactions that were made were entirely consistent with that legislative standard?
I can confirm that the redactions that were made were consistent with the definitions under the Access to Information Act, yes.
I just want to follow up on a line of questioning that Mr. Julian made about the percentage of documents that were redacted. His questions asked if they were wholly or partially redacted. When you gave those percentages, that was the number of pages that included a redaction, not a page that was redacted in full, correct?
Yes.
So when Mr. Julian says we're up to 600 pages, that might include one page that included the personal cell phone number of an individual public servant?
Yes.
Okay, so in fact, the true volume would not be 600 pages at all. It would be a much smaller amount.
If you're looking at the volume of redactions, yes.
Okay, I want to ask one final question. Thank you, Mr. Chair. And it follows up on Mr. Poilievre's line of questioning about the second motion about document production. Before you got too far down this path, you answered that the disclosure requested in the second motion was predicated on the parameters of the July 7th motion. There's a principle of law about how you interpret lists. When you describe a general category that includes subcategories, those subcategories only fall within, only are required if they fall within the broader category. In the second motion, and I think this is what you're getting at, but I'm curious as to your opinion, were you saying that because the second motion only requested documents that were requested in the first motion, that in fact the subcategories requested were only requested insofar as they were requested in the July 7th motion?
Well, that's my understanding, but at the end of the day, it's up to the committee to make its determination on that point.
Yes, and look, I was only asking for your interpretation, so thank you very much. I appreciate that.
Thank you both. Are we on to Mr. Kelly or Mr. Poilievre? Who's on?
Yes,
Mr. Poilievre, okay, and you'll be followed by Ms. Koutrakis, I believe. Mr. Poilievre.
Can you point me, Mr. Dufresne, to an exclusion, to where in any of the motions that the committee has adopted, the government was permitted to black out information that it considered to be irrelevant?
I do not believe that's stated in either of the motions.
Right. So Mr. Fraser's whole line of questioning comes crashing down like a house of cards. He was claiming that somehow the irrelevant exclusion was contained in the original motion. It was not, as you've just confirmed. It was not included in the second motion. And therefore, the government was in no way empowered to black out things it considered to be irrelevant. And there could be all kinds of evidence of corruption related to this scandal that they consider irrelevant to the public. I mean, let's remember, this is a scandal about the Prime Minister personally intervening to award $500 million to a group that gave his family $500,000. This is the kind of corruption that puts politicians behind bars in other countries. But it's the kind of corruption that is apparently accepted in this government. And now we expect the same government that engages in these practices to have the authority to black out information that it doesn't consider relevant to the public. Well, that is not what this committee requested. Mr. Fraser personally committed to me and to this committee that the only information that would be excluded in the disclosure to you would be on the grounds of cabinet confidence. And that is a commitment that he and the government have violated, and that will have to be taken into consideration the next time we agree to a compromise with him and with members of the government. Very disappointed to learn that they did not honor their commitment that we agreed to when we passed the second motion in November. Mr. Clerk, going back to our original discussion about witness appearances, I'm going to again read from the report you gave me. In order to facilitate witnesses' attendance, the committee presented a report to the House requesting that the Speaker issue a warrant for his appearance. The House subsequently concurred in the report. In other words, a committee can pass a motion seeking a warrant to physically compel witnesses to appear, and if the House then concurs in that, the issuance of that warrant, then the Speaker would then seek law enforcement to carry it out. Is that your understanding, Mr. Dufresne?
Well, the committee would first adopt a motion to issue a summons, and then serve that summons on the witness and see if the witness complies. If it did not, then the committee could report the matter to the House, and the House could instruct Sergeant at Arms to take necessary steps.
And what would those steps include in that case?
Well, those steps could include bringing the individual to the committee or to the bar of the House.
And who would bring them to the committee?
This is something that would be coordinated with, according to the House's direction, with the Sergeant at Arms office and potential authorities. As I said, we have not seen that. The latest precedent was bringing Mr. Karl-Heinz Schreiber to testify while he was incarcerated. So a warrant was issued so he could be brought from that institution to the committee. It's a different situation.
So the Sergeant at Arms would use law enforcement in order to compel an appearance in those circumstances.
If this were ordered by the House, as I say, which it has not been in a long time.
Right, but the authority is there, that we are the grand inquest of the nation, and therefore we have the power to convene any persons for testimony, whether
Last
they
question,
agree or not.
Mr. Poilievre.
And as the grand inquest of the nation, do we have the power to compel anyone on Canadian soil to appear and testify as Parliament?
Well, you have the power to order them, and the House then has disciplinary powers if there's a breach. It could include a finding of contempt of Parliament. It could be calling the individual to the bar of the House.
Okay, thank you both. We will go next to Ms. Koutrakis, and then to give a heads up, we are back to the Bloc for 2.5 minutes, the NDP for 2.5 minutes, the Conservatives for 5, and the Liberals for 5. So Ms. Koutrakis.
Thank you, Mr. Chair, and thank you, Mr. Dufresne, for your testimony before the Finance Committee this afternoon. Before I'd like to add my comments and to Mr. Poilievre's comments, calling into question my participation here as a Liberal member of the Finance Committee. As everybody knows, this is, I'm a relatively new MP. It's my first mandate, but I can tell you, nobody has ever questioned, my integrity or whether I, as a Liberal member or otherwise, have negotiated in good faith. So I don't appreciate, and I want this on the records, I do not appreciate receiving, comments and shaming me and my Liberal caucus members on this committee, because I know that everybody on this committee, regardless of party, works in good faith. And I'd like to believe that we are given the same courtesy. Mr. Dufresne, how important is it for governments to determine information that is considered cabinet confidence or irrelevant to the issue at hand without sharing this information with the Office of the Law Clerk? And why are these safeguards in place?
Well, I think that the clerk of the Privy Council testified to that more eloquently than I could in terms of why the government acts and feels the way that it does. And what I can say is that the government has, in the public service and clerks of the Privy Council, consistently defended cabinet confidences, irrespective of political party and power. We have a neutral, nonpartisan public service in this country, and they serve the interest of the executive branch in a nonpartisan, impartial way, as my office serves the interest of the legislative branch. So in terms of cabinet confidence, as I say, the testimony from the clerk was eloquent and talked about the necessary for ministers to be able to speak frankly and to have discussions in cabinet. And then once the decision is made and cabinet solidarity requires all to defend the decision, then that needs to be protected. So that's the basis for the government's court quite rightly noted that cabinet confidence have been recognized by the Supreme Court of Canada. So it is not something to be taken lightly. My point here today is that in my view, the House, as the grand inquest of the nation, does have the power to request all information, but should give weight, and perhaps significant weight, to some of those public policy considerations.
And thank you for that. And thank you for echoing what I too believe, that we have an amazing impartial civil service branch, and we should never, ever, either indirectly or directly, accuse them of being anything but impartial. And I thank them for their service. With some members of this committee suggesting that information considered cabinet confidences or irrelevant should be reviewed by those outside of the government and members of the public service, are you at all concerned that this may create a dangerous precedent going forward? And I would also like to hear your comments, Mr. Dufresne. How could we do better as a committee going forward when we're putting motions like this? How can it be clearer so that we don't run into these issues going forward?
Thank you. I think on the issue of whether it would create a dangerous precedent for the committee or for my office to review cabinet confidences, I would simply point out that committees and House have been creative in the past, including in the Afghan detainee matter, which dealt with very confidential issues of national security. And the Speaker noted that members of Parliament ought to be trusted. They have the political democratic legitimacy, and if need be, as was the case in that case, there were some sworn statements of confidentiality and these types of measures. So my response to that point is there may well be ways of achieving the necessary levels of safety, even for something like cabinet confidence. In terms of your second question, I'm sorry, can you repeat the second part of your question?
My second part is, looking to you for guidance, being,
Sorry.
Right? How could we, how can we do this better going forward?
Thank you. So I think that the more the committees in their motions can set out the grounds that it considers acceptable for redactions, the better it will be, because it is the committee's authority to make those determinations. And so that would avoid situations where there are grounds that are put forward that the committee has not necessarily adopted, and it creates these types of issues as have occurred in this matter.
Do I have time for one more?
Okay, we'll give you one more.
If in the wording of the motion we had, specifically included that we should use legislative standards, would that have made a difference with the documents in how they were presented?
Well, it would have certainly strengthened the argument that those grounds ought to be included. I think my advice would be to be as specific as possible, if either to set the grounds themselves, because or if referring to a statute, it would be better to refer to a specific statute. So again, what matters is not so much the form, but that the committee turn its mind and confirm that it is endorsing those grounds or any given process. As I say, sometimes the issue is making the document public to the world, as opposed to making it known to the committee members, who may well need to know, but it may need to be maintained confidential and not go beyond the committee members, for instance.
Okay, thank you both. Ms. Gill will go with about 3 minutes, and the same with Mr. Julian. Ms. Gill.
Merci, Monsieur.
Thank you, Mr. Chairman. So I had a response from my colleague from BIMI as to the best way to do things, because what we're seeing here is that everything turns on the issue of confidentiality for the committee, but also amongst elected members themselves, who are representatives of Quebecers and Canadians here. And we realize that the practice or the exception that isn't the norm becomes, in terms of redaction, the standard. And so we have to have confidence in elected members to respect confidentiality. As Mr. Dufresne said, there are 5 ways to protect confidentiality. And we can use these, so why don't we? We talked about this. I don't have all the figures in front of me, but we're talking about perhaps 15% of the documents that were redacted. So there are ways, as I just said, that we would be able to preserve that confidence and confidentiality, rather. And I'm worried because it's the committee that orders the production of documents and not the Prime Minister or the Prime Minister's office. What I'd like to know, Mr. Dufresne, because we talked about 5,000 pages, and of course the committee didn't ask to have every single document tied to the We Charity issue to be produced. And I mean, even if we're doing this in camera, do you think that we would have found relevant information, additional relevant information? And of course, that would be within the framework of our study. Well, it's really difficult for me to answer that question because we really looked at the documents to see if it corresponds to grounds that have been invoked in terms of the redaction. So a priori, if it was included in the documents, it was relevant. But the question was it really on the grounds that were identified? So just for clarification, when we're talking about percentages, we were talking about the number of pages and not the number of documents. And Ms. Gauthier is telling me that for the non-relevant documents that we talked about in the July request, we're talking about some 20 pages in the second disclosure. So that's it. Thank you. I still have some time, Mr. Chairman. So perhaps to come back to my first question, we always come back to the beginning. You said that, yes, it has happened that these kinds of redactions have been made by officials. But can you talked about the Afghan mission, but can you think of another example where documents were redacted without the committee having made that request? Well, I think I'd have to go back and look at the committees carrying out those investigations. But I can say that for sure it has happened. We saw it in the testimony, and the testimony of the clerk of the Privy Council, that the public service is bound, in their opinion, by this legislation. And so we do see that. And it's something that is raised from time to time. We saw it with the Afghan mission and other cases. So I understand you don't have those examples in mind, but is it possible that you provide the committee with them later? Well, we can see with the committee team if we can see how frequently this has happened, this practice. And also the substance of it as well. It's not just quantity, it's quality. Thank you.
Thank you both. We'll move on to Mr. Julian for about 3.5, 4 minutes, and then we'll go to, I believe, Mr. Kelly. Mr. Julian.
Merci beaucoup, Monsieur le Président.
Thank you very much, Mr. Chairman, and thank you, Ms. Gauthier and Mr. Dufresne, for being with us today. We're learning a great deal. So, just more or less with the figures that you gave to Ms. Gill, we're talking about more than 620 pages that were either completely or partially redacted. Is that not correct? Is that the correct number? Well, I think we could perhaps send you a written confirmation of that statistic after the meeting so that it would be useful. I think indeed that it would be probably over 600 pages. So. But once again, with the clarification, we're not talking about entire pages. In some cases, it's a tiny fraction of a page, but it's still counted as a page. Well, yes, but at the same time, sometimes it's the entire page. So I understand we have to be clear and precise. And I appreciate your being so specific on this. But what my Liberal colleague said, that it's just a telephone call, well, it's not the case in the majority of the time. Now, the documents that we received just before the prorogation, when everything was shut down, and afterwards there were the filibusters that ate up a lot of time at the Finance Committee over a couple of months. There were some 1,000 pages that we're talking about that were partially or fully redacted. Isn't that right? Well, I'll have to confirm that information, but what you have to realize as well is that my office also made redactions to those documents as requested by the committee. So in my August letter, I spoke of these redactions, particularly I mentioned the names of officials that were redacted by my office. And there was the mention of protecting those officials. So some were my redactions and some were the government's. But there again, you'll be able to give us more specific figures on that over the next few days? Yes. Thank you very much. I greatly appreciate that, Mr. Dufresne. Honestly, I'm very frustrated as a member of the House of Commons and also as a member of this committee. We were given the precise task after the beginning of the pandemic and that the proceedings in the House were suspended. We had to go through all of government's expenditures to ensure that these were spent, that these monies were spent properly and correctly. There were some questionable expenditures, and that's what we were trying to do this last summer. And we know what happened afterwards. The Prime Minister's office shut down Parliament. And there were questions asked at the Finance Committee. And now we're learning what the scope is and the volume of all of the documents that were redacted. And it's over 600 pages. So as a member of Parliament, I say, and this is a comment rather than a question, Mr. Dufresne, if I may, I would take the opportunity to do so. It will be extremely for this committee to get to the bottom of this and see these documents without the redactions, and following that, make public what should be made public. I think that it's our responsibility that was given us by the House of Commons to this Finance Committee at the beginning of this whole crisis.
Mr. Dufresne, is anything he wants to add to that or not?
No, Mr. Chair.
Okay, all right. We're back to Mr. Poilievre or Mr. Kelly? Who's on? Okay, Mr. Poilievre, and that'll be followed by Mr. Fraser. Pierre, floor is yours.
Merci. Juste pour résumer, on parle d'un...
Just to summarize, we're talking about a scandal where the Prime Minister intervened to give a contract, a $1 billion contract, to a group that had given $500,000 to his family. So as committee, we wanted to receive all documents associated. We didn't want to receive censored and hundreds of pages of censored documents. And after obstructing us and filibustering for the longest time, the government basically said, oh yeah, we'll give you all the documents except what is in cabinet confidence. But what we're learning today is that, contrary to what they said, the government did redact even more documents based on the fact that these documents were not relevant. You have confirmed today, Mr. Clerk, that the government did not honor the motion of this committee, that is to produce all these documents without redactions, and as well that there are still some redacted documents. Redacted why? Because apparently they're not relevant. And thirdly, this confirms that you cannot know if these redactions that are allegedly based on cabinet confidence is the real reason. In what I just said, is there anything you want to address, sir? Answer. Well, I believe that the point that was raised with Mr. Fraser regarding the interpretation of the November motion, in other words, was it appropriate or not regarding the non-relevant documents? So I think that I said to that regard that, in fact, these documents were not within the purview of the initial motion, but we don't know. We don't know because we don't know what those documents are exactly. We don't know if that content is relevant or not because the government basically does not allow us to see what the content is, does not allow you to see what it is, so you can't magically see what is behind the redaction. That is correct. But regarding my other question, the Kielburgers say that they don't want to testify before committee, even if they are summoned by the committee. But based on a document that you produced today, the House of Commons has the right to imprison people, even though that right has not been applied since 1913. In the years immediately following Confederation, the House of Commons has ordered for the imprisonment or detention of individuals on 4 occasions. The House ordered the Sergeant-at-Arms to imprison 1 person back in 1913. I agree with you. It is certainly not our will to imprison anyone. But I just want to confirm with you in French, what you've already told us in English previously, that in the worst case scenario, if a witness refuses to testify after being summoned by Parliament, we do have the power to call upon the Sergeant-at-Arms and call upon the police forces to compel testimony. Answer. What I said is that while we went through the history of that power as exercised by the Chamber, the last time was back in 1913, and I spoke about all the other precedents prior to 1913, so it is certainly something that is not common or recent, but the House of Commons can, in fact, find that somebody acted contrary to the will of Parliament, but that is a power that has not been invoked in the longest time, and of course that would raise some questions. Yes, but how much time do I have left, Mr. Speaker?
To make it quick.
Donc, et aussi, on voit.
All right, and we see in the report as well, in the report that you shared, that back in 2007, one of the committees did exercise some of that power in the Karl-Heinz Schreiber case so that he be compelled to testify before the House of Commons. So when people say that they refuse to come before a committee, as parliamentarians, we do have the power to summon them, to compel them to testify, and it is a tool that could be at our disposal, lest they be cited for contempt. Yes, in fact, and I did speak about that precedent in the Schreiber case, who was imprisoned and who was compelled to testify before the committee. Thank you, says Mr. Poilievre.
Thank you both. We'll now turn to Mr. Fraser, and we'll have time for another couple of quick questions after Mr. Fraser. Mr. Fraser.
Thank you, Mr. Chair. Mr. Dufresne, I just had a note come through that Mr. Poilievre has tweeted out not long ago that during this meeting that you have revealed that the government did not reveal that all the documents the Finance Committee ordered released in the summer, and that the government is blacking out information it claims is not relevant. From your testimony, I don't think that's a fair description. I think what you actually have said is that the non-partisan public service has redacted information that was not relevant because this committee didn't ask for it in the first place. Is that a better characterization of your testimony?
Point of order, Mr. Chair.
What's your point of order, Mr. Poilievre?
The member is asking the clerk to comment on the relevance of content that he has not seen. He hasn't seen the document.
Mr. Poilievre, that is not a point of order. That is not a point of order.
It is unfair to ask someone to comment on something they've not seen.
Well,
I think
not,
that's happened here before. That's not a point of order. Mr. Fraser, the floor is yours.
Thank you. Well, Mr. Chair, I'll inform the clerk that Mr. Poilievre has made a tweet indicating that the government has redacted documents that this committee ordered produced in the summer. The testimony that you gave earlier is contrary to what Mr. Poilievre has asserted. Is it a better characterization?
Point of order, Mr. Chair.
What's your point of order?
Well, now Mr. Fraser wants to mischaracterize my tweet and ask the law clerk to comment on it.
Mr. Poilievre, that is not a point of order. I'm sorry, that's not a point of order. Mr. Fraser has the floor. Maybe you could send us your tweet and we would know. Mr. Fraser.
In any event, Mr. Poilievre during this meeting has made the assertion, or at least attempted to make the assertion, that the government has redacted information that the committee ordered produced in the summer on the basis that it is not relevant. My understanding of your testimony was that the nonpartisan public service redacted information on the basis of relevance because the committee did not ask for it in the first place. Is that a fair assessment?
Point of order, Mr. Chair.
I'm not. What's your point of order? I'm going to Mr. Dufresne to answer this question. Mr. Poilievre, what's your point of order?
That is not, in fact, what I tweeted. So he's asking for the clerk to contradict something that I didn't say.
That's not a point of order. It's a matter of debate. Mr. Dufresne, you've heard the discussion earlier. You've heard Mr. Fraser's question. Could you answer Mr. Fraser's question as asked?
Your description is fair, Mr. Fraser. I would agree with that characterization, and that it's the redactions were made, as it seems to me, from the public service and nonpartisan public service, and on the argument that not relevant would not be part of the original motion.
So there's no way, shape, or form, in your opinion, based on what you know, that the redaction of information on the basis of relevance would constitute a violation of the privilege of this committee, based on your interpretation?
I'm not raising that as a concern. What I've raised is invoking grounds in the Access to Information Act that were not part of the committee's motion, and flagged that it's for the committee to decide if it wants to accept those.
Thank you. I think that's very clear that your concern is not on the batch of documents marked not relevant, but other documents. On the issue of relevance, Mr. Poilievre made the point earlier in this meeting that there was no explicit power to exclude the documents based on relevant, but of course, if documents are not asked for, they need not be produced. I'm curious if you would agree with me that documents that may pertain to, say, vaccine procurement or domestic production of PPE that may have been redacted, are those similar in kind, in your view, to the other documents that would be within the custody of the Government of Canada on other issues that did not pertain to the motion?
I'm not sure I understand your question, but what I would say is that to me, something that's not relevant is something that is simply beyond the scope of the motion. So the motion will ask documents about a certain topic, and if it's not about that topic, then it's not relevant.
Thank you. I guess my concern is that if the government was required to produce all the information that was not relevant, there would be an endless reams and reams of millions of documents that would be impossible to satisfy that motion. I see you nodding. I take it you agree.
Well, I think everything that's not relevant is the infinity of whatever is left. So it could be significant.
Thank you. Mr. Chair, is there any time remaining? I'd like to give
you've got about, we lost a little time there, so you got about a minute and a half.
Ms. Zarowitz, I think you had a question or two you wanted to ask.
She'll have time later if you want to take another minute there. Yeah.
Well, look, maybe just to wrap up, Mr. Chair, just a summary of some of the things that I've heard you say, and at the end, Mr. Dufresne, if you could just confirm whether my assessment of your testimony is accurate. That the government made redactions pursuant to cabinet confidences, pursuant to relevancy, and that they were entitled to do so. And as so far as you can tell, those were made by the independent public service. You also indicated that although you have some concerns about the access to information grounds, if the legislative standard was actually the one that was properly applied, that it was done and consistent with those legislative standards. Is all of that accurate in your view?
I would agree with that.
Okay, and just a final piece of confirmation. When you do provide the information that Mr. Julian requested, and I believe Madame Gill requested about the number of pages, is it possible for you to actually demonstrate to us, not in terms of how many pages were wholly or partially redacted, because you did make the point that some of these have very, very small redactions. I've seen some of the documents that the government produced. I've not seen the unredacted versions of them, but you can tell that some of them are clearly labeled a cell phone number on an entire page, and that's the only piece that's been redacted. Is it possible for you to actually demonstrate to us in some quantitative way how much of the document package was actually redacted, rather than having a page statement, which would obviously artificially inflate the sense of the redactions?
We will bear that in mind and try to have information that is as useful as possible in terms of giving a sense of scale.
If I could ask one additional favor of you before I finish my questioning, Monsieur Dufresne. Ms. Zarowitz asked previously about the public interest that is served by some of the exemptions to production outlined in the access to information legislation. If you could offer a summary of the reasons that those exemptions exist, I would be grateful as a committee member.
Are you asking me to do this now or to do the?
No. I think on a follow-up basis, I don't think we have time in the limited questioning I have remaining.
I think we're looking for that, Mr. Dufresne, in writing.
Okay.
We've got about 3 minutes for a question from the Conservatives and 3 minutes from the Liberals. Are you on, Mr. Poilievre, or Mr. Kelly?
So,
okay, Mr. Poilievre.
Mr. Chair, to confirm that what we said all along, Conservatives were never looking for every irrelevant document to be included. We were looking for documents that the government covered up with black ink on the grounds that they claimed it was irrelevant to be viewed by the clerk. And the reason for that is to ascertain if, in fact, the information contained under that ink was irrelevant, something that the clerk cannot confirm because he has not seen it. And if it were completely unrelated, then it would not have been included in the disclosure in the first place. Obviously, information not relevant would not have been included, because as Mr. Fraser correctly points out, that would have been literally millions or even billions of pages. But we're talking about information that was included, but blacked out. And if the government has nothing to hide, if in fact this is just unrelated information about, say, PPE procurement, as Mr. Fraser claims, they would have let the clerk look at it and confirm as much. And he could have, in a confidential way, determined the relevance. So I ask again, Mr. Dufresne, did you have the ability to look at information marked not relevant to confirm whether, in fact, it was or was not relevant?
No.
No. So there you go. Again, Mr. Fraser expects us just to take the government's word that nothing behind the black ink was relevant to Canadians. Furthermore, the government is saying that there is no precedent for cabinet confidences to be reviewed by parliamentary committees in manners that are protected from public disclosure. Can you confirm that in the Afghan detainee controversy, that a parliamentary committee was able to look at those sorts of things in private without public disclosure?
The Afghan detainee did not raise cabinet confidence as the ground. It was the ground of national security. So there may be an argument that cabinet confidence is distinct, but certainly with respect to the very sensitive national security information, there was a compromise solution that was found with the creation of an ad hoc committee of parliamentarians and the support of a panel of judges, former judges, who could make determinations on issues whether certain things could be released publicly.
And did any of the members of parliament then breach their duties of confidentiality and jeopardize national security when they were given private access to that information?
Not to my knowledge.
Right. So there is a precedent, a successful precedent under a previous government. It was conservative, but that's actually not relevant. That allowed members of parliament to scrutinize secret and confidential sensitive information without imperiling the public interest. So I thank you very much, Mr. Dufresne, for your work, and I wish you well.
That will end that round there. Ms. Zurwitz, you'll have to wrap it up.
Oh, thank you so much, Mr. Chair. And there might be time for 1 minute that if one of my colleagues might have another question. I just want to correct for the record, Mr. Chair, because I think it's important to do in these cases. I think that my colleague, Mr. Poilievre, made a statement that was not true, where he indicated the Prime Minister intervened to give We Charity the contract, a $500,000 contract. That has proven to be completely not true through all the evidence that we have actually heard through the summer. And I think that we need to make sure that that is on the record in this meeting. I also want to maybe sort of address what Mr. Poilievre just said in terms of that we have to take the government's word in terms of the documents were not relevant. I want to remind everyone that when we're saying the government, this is a non-partisan civil servants who actually are responsible to ensure that the documents follow the committee's instructions and to provide these the documents as instructed. And so my question to you, Mr. Dufresne, because I want to make sure this is crystal clear in the minds and in the understanding of anyone who's actually listening to us. Have you seen, or has there been any evidence, in your view, of any political interference in the work that our civil servants have done to actually provide us with this information?
I have not seen any.
Thank you very much. Those are all my questions, Mr. Chair.
Okay. Ms. May, did you have one question? Then ask it.
Okay, thank you.
You get time for one.
Yeah. In your opinion, Mr. Dufresne, was the material that was provided to this committee responsive to the request you received?
To the request I received?
It's not the request you received, but the request made by the committee, sorry, that you reviewed.
Well, it was, but for the claim of those grounds under the Access to Information Act that I have identified.
That is very clear. Thank you very much.
Okay, a good point to end on. With that, thank you to the witnesses, Mr. Dufresne, Ms. Gauthier, and thank you to all the members who raised very intense questions. I think we had a very lively discussion. Thank you to the witnesses. With that, meeting adjourned.